Let me paint a picture. You build a business, you train your team, you invest in them, not just with money, but with your time, your trust, and your trade secrets. Then one day they leave, and by the end of the week, they're calling your clients, replicating your services, and launching a competitor 2 blocks down the street. For years, that's been a nightmare scenario for Florida businesses. And with everything happening nationally, the federal push to ban non-competes, you might think protections for business owners are vanishing. But not here. Not in Florida. Florida just did the opposite. We passed a law effective July 1st that actually strengthens non-compete agreements, and not just a little. This is one of the most employer-friendly non-compete laws in the country. If you're a business owner, you now have more legal tools than ever to protect your competitive edge. I'm Santiago Cueto. I'm a board-certified international business law expert and founder of Cueto Law Group and best-selling author. I've spent nearly 3 decades helping business owners navigate the fine print, the contracts, the risks, the litigation. And this right now is one of the biggest shifts I've seen in employment law in a long time. The new law is called the Choice Act. That stands for Contracts Honoring Opportunity Investment, Confidentiality, and Economic Growth. And yes, it's a mouthful. But what it really means is that Florida is planting a flag. We're telling the country and the world that we protect innovation, investment, and private enterprise. And that means if you're running a business here and you're hiring high-level talent, you have every right to expect that talent won't turn around and compete against you. Here's what's changed. If you got key employees, people earning at least twice the average wage in your county, Florida law now says you can enforce non-compete agreements for up to 4 years after they leave your company. That's double what it used to be. And for certain types of contracts, the law even recognizes garden leave arrangements, which means you can pay someone to sit out their notice period while keeping them from immediately jumping ship. That's a huge deal because now courts in Florida are required to presume that these agreements are valid and enforceable. And if you go to court to stop a former executive from violating a non-compete, the judge has to act quickly. In many cases, they're required to grant a temporary injunction, basically freezing the situation unless the employee can prove that working for your competitor won't hurt your business. This flips the script. For years, employers had to scramble to prove harm to justify every restriction. Now, it's the former employee who has the burden of proof. That's a powerful shift. But let me be clear, this isn't a free-for-all. The law is still nuanced. It only applies to certain employees, those at a higher income level, and only if the agreement is properly drafted, clearly communicated, and tied to legitimate business interest, like protecting client relationships, trade secrets, or confidential strategies. What this means for you in real terms is that it's time to revisit your contracts. Not tomorrow, not next quarter, now. Because if you're still using old templates or cookie cutter language, you may be missing the opportunity to fully leverage this new law. And I say that as someone who's litigated these agreements in court. I've seen what works and what falls apart under scrutiny. The difference often comes down to the details, how the agreement defines competition, how it describes confidential information, how it frames the geographic scope. Under the Choice Act, the law gives you the advantage, but you've got to use it wisely. I know some people have raised concerns. Their voices saying these types of law will stifle innovation or limit employee mobility. I get that, and I agree. No one should be locked out of their industry unfairly. But this law doesn't prevent someone from earning a living. It just says if you were entrusted with the keys to the kingdom, you can't turn around and use those keys to build a competing empire, at least not immediately. That's just not fair. That's common sense. Florida is making it clear. We welcome talent. We reward entrepreneurship. But we also respect the rights of business owners to protect what they've built. So if you're hiring C-suite executives, top-level engineers, high-end salespeople, now's the time to reinforce your contracts, review them, update them, and make sure they're drafted not just to look good, but to actually hold up in court. Because this law gives you the power, but it's up to you to use it. Again, I'm Santiago Cueto. I help businesses stay one step ahead of legal risks because in today's climate, what you don't know about your own contracts can cost you everything.